Good afternoon, everybody. Welcome to today's program on the second impeachment of Donald Trump. I'm Jason Mazzoni, and I'm joined by my colleagues here at the University of Illinois College of Law, Andy Leopold and Vic Amar. This might seem familiar to some of you. Less than a year ago, the three of us did a similar program on the first impeachment of then President Trump, which, as you know, probably resulted in a trial and acquittal in the Senate. And so here we are again on Groundhog Day, and we even just dusted off the same poster that we used last time to advertise the event. Impeachment of a president is supposed to be a once in a lifetime event, not an annual occurrence. I doubt we'll be doing this a year from now, but maybe within the next few years we'll have another one of these. Maybe it is becoming more routine than we would have thought. Or perhaps Trump is unusual. There have only been 4 times presidents have been impeached. Trump represents 2 of those occasions. And no president before has ever been tried in the Senate after leaving office. The impeachment process against President Nixon shut down with his resignation. For those who work in constitutional law, the Trump administration, I think it's fair to say, has been pretty good for business. It generated regularly some unusual issues of constitutional law, put to a test some of the features of the Constitution, required us to really think hard about some problems. And this is true in some, but not all respects, with this now second impeachment and second trial of former President Trump that's coming up. I want to mention a couple of things that I've been thinking about, and then we'll hear from Andy and then from Vic. And we should have some time for questions and answers as well. So first, this time we have a single article of impeachment. It was approved very quickly by the House. And remember, impeachment is the accusation. It's just the charge. So we have a single article, and it's titled Incitement of Insurrection. And in the first paragraph, it says the president engaged in high crimes and misdemeanors by inciting violence against the government of the United States. I want to say a couple of things about that. An impeachment doesn't have to involve something that is a crime under statutory law. And even if it doesn't have to follow the statutory definition. Here we do have a charge that has statutory analogs. Incitement of insurrection is a crime under federal law, and many state statutes have similar criminal. Many states have similar criminal statutes. The usual definition of incitement of insurrection is that you encouraged, provoked others to engage in rebellion against the government using violence. And they did it, that those others did it immediately on your prompting, or they would have done it had the police not intervened right away to stop them. Government, and again, talking about the criminal context, government doesn't really prosecute too many people for incitement anymore. These are very hard cases to win. And courts, including the Supreme Court, have been very skeptical of incitement statutes and prosecutions under them because they sweep in speech that is protected by the First Amendment. So either you don't have the evidence of immediacy and you can't prove the charge, or if you proceed without that evidence, there's a First Amendment problem. There's also, I might say, there's an unfortunate history here as well. Incitement of insurrection has been used historically largely for political suppression, used to prosecute organizers of labor protests, union activities, communists for advocating new forms of government, civil rights organizers, and earlier used against abolitionists for encouraging slave rebellions. Incitement to insurrection was punishable by death in the slave states. So after this article was voted on, members of the House in charge of the process said, we don't mean the exact criminal definition of incitement. They also said the First Amendment standards in Brandenburg, a case you may know about, and other cases don't apply to presidential conduct and impeachment matters. The House leaders, I think, recognize you almost certainly couldn't get an incitement conviction under the criminal law. So they want to distinguish the criminal definition, and they want to set to one side the First Amendment. I suspect this is going to be lost on the public. We're going to hear, I'm pretty confident next week at the trial that nothing the president said or did rises to the level of incitement of an insurrection. And Democrats don't believe in the First Amendment. They're going after political opponents in the same way that has been true with historical charges of incitement. So here maybe I think the framing of this as incitement of insurrection was a mistake. I don't think the House really means or only means incitement. So if you read the remainder of the article of impeachment, it's actually a broader sounding charge. The president had claimed for several weeks repeatedly without any evidence that the election was fraudulent. That, it seems to me, is the basis for the real charge, the real complaint here. But the House sort of buries the lead. It's only in the last paragraphs of the article that you get the president threatened the integrity of the democratic system and a peaceful transfer of power through a sequence of activities beginning the day after the election. Now, of course, if there were dead people voting or people voting twice or ballot counters cheating, we'd really want to hear about that. But for a sitting president to announce repeatedly as fact that democracy failed, that your votes didn't matter, that the incoming administration isn't legitimate, that it's like, China or Myanmar or Russia, or that seems to me the real complaint. In this sense that the House has maybe called it the wrong thing, packaged it wrongly as incitement in a way that allows for a challenge to the charge that will sound or may sound powerful. If you read the Trump speech on January 6th, the argument will be, well, he didn't say anything specifically that would constitute an incitement of the breach of the Capitol. We shouldn't be punishing mere speech, especially political speech. The House trial brief that was released today and that I was just looking at before the session is more detailed than the article of impeachment, not surprisingly. And it opens with a long discussion of Trump's claims of electoral fraud. But again, I think a bit of a misstep. It all reads as background to the January 6th rally and riot, essentially saying that Trump fired up supporters over several weeks, and they then came to Washington angry, and the January 6th rally is where the fuse is lit, and that's incitement. So again, rather than say the many weeks of asserting electoral fraud and claiming the incoming president has seized power unlawfully, it was itself say an abuse of office, grounds for impeachment, even without the breach of the Capitol. It's all packaged in an incitement charge in a way that I think obscures some important things. And on that point, maybe back to the criminal sort of understanding of incitement, which this isn't, of course, a criminal prosecution, but the criminal definition overhangs and will overhang, I think, the formulation of the charge. If your account is, as the House trial brief seems to suggest, that Trump complained about the election over many weeks and these people came to Washington through their own planning, ready to engage in violence, then it's harder to say there was incitement on January 6th. So again, I'm not at all sure about the packaging of this. The second general observation, just quickly, is concerns the speed with which the House approved this article. So if you remember the first time around when we had two articles of impeachment, abuse of power and obstruction of Congress, arising largely out of dealings with Ukraine, the House spent a long time conducting investigations. I think most of the fall of 2019, investigations by 3 committees, public hearings before the Intelligence Committee, the Judiciary Committee, mountains of evidence before the House itself voted. So by the time it all got to the Senate, there was a very comprehensive record. And if you remember the trial, we don't need any witnesses, there's some truth to that the House had really left no stone unturned. This time around, it's very different. No House committee involved. The article is introduced in the House on January 11. It bypasses the usual committee process. It has 218 co-sponsors, so you already know the result. It's debated in the House in one day. It's voted on January 13. No hearings, no witnesses, no experts. Now, part of this is there's less to investigate compared to figuring out what happened with Ukraine. Part of it is the witnesses, or at least some of them are members of the House itself, right, who were at the Capitol on January 6th. But part of it also was, I think, a strong desire to approve this thing before Trump left office. We're going to hear next week that impeachment of a former president is unconstitutional. But remember, when you hear that, he was impeached while in office. So the question is a bit more specific. It's trial of a former president on a charge of impeachment voted on before he left office. That seems to me a more specific constitutional question. And if you focus on that, it deflates some of the some of the big arguments that no former official is safe. We can gear up the process years after they've all left office. Senator Cruz recently said, next it might be Obama. We can always find something on him. The trial of Trump doesn't necessarily lead to any of that, because the impeachment occurred while in office. And maybe here the text of the Constitution is quite relevant. Under Article 1, the Senate has power to try all impeachments. And there's no question that the impeachment itself by the House was timely. It was an impeachment of a president in office. Another quick point about the speed of the process in the House. I think a fast impeachment by the House would generally put pressure on the Senate to hold what looks like a real trial. The Constitution gives the Senate power to try impeachment. It doesn't say what kind of trial, but the more truncated things are in the House, the more you probably want to see evidence developed in the Senate. We know already that they're not going to spend the next 2 months conducting a trial. So there's some question, I think, about the development of the record here. The evidence in the House trial brief, again, it was just released today. It's largely newspaper reports and stuff pulled from websites. You couldn't rely on that as evidence in a criminal case, but it's not a criminal prosecution, so the evidentiary rules in criminal trials don't apply. Nonetheless, I think it would be notable if you have a process in which neither the House nor the Senate actually gathers live testimony or gathers very little of it. There's this old saying: if you can't win on the facts, you emphasize the law. If you can't win on the law, you emphasize the facts. I'm gonna be watching to see which side is emphasizing which. Okay, so that's my 10 minutes, and now I think over to you, Andy.
Thanks, Jason, and thanks to all of you for joining us today. I'm going to leave to our con law experts the question of whether the trial is constitutional or not constitutional, including the really interesting, at least to me, question about the Chief Justice's role in this, whether he can, take a trial off or whether he's required to be there. But I'll leave that to the others. I'd just like to say a few words about the second trial and whether it's might be a good idea or a bad idea. And in particular, I want to focus on the question or the issue: just because you can, does that mean you should? What do we get? What do we not get from a second trial? And does that reach the goals that we're trying to reach in this whole process? So I'm going to share a screen here because it's a lot more interesting than looking at me. I hope everyone can see the why a second trial blackboard there. Because I'm, a geek, I think of these things in terms of criminal law. What's the purpose of holding a second trial? What will we accomplish by it? And the first one, of course, is retribution. We are doing it because he deserves it, right? Because the president did, while he was in office, did some bad things. And personally, I'm still stuck on the phone call to the Georgia guy asking him to find some extra votes. I think the insurrections are bad, but there's a lot of behavior here. And the idea that sort of he deserves it, I have a lot of sympathy to. Or to put the point somewhat differently, we have to do something. We can't let behavior like this go sort of unremedied. Well, he's already been impeached, and as Jason pointed out, that's not going to change. And I'm not entirely sure how much better we're going to feel, whether we're going to feel like justice was done when it appears that he will be acquitted. And so part of the variation on this theme of the people that are really pressing hard for this second trial is, okay, even if we're not going to give the president his just desserts, the former president his just desserts, let's at least punish his enablers, right? Let's force the Republicans in Congress to vote to acquit and thereby signal that they approve of the behavior that's the subject of the article of impeachment. Yeah, maybe, but perhaps not surprisingly, the Republicans kind of thought of that. And so they're going to stand and say, this is an unconstitutional proceeding. And if as it now appears, the president will be acquitted of the charge, I'm not sure that the Republicans will really be pressed into the kind of position that their opponents hope that they will be. Um, Plus, this let's punish his accomplices has the problem, at least I think, of using the impeachment trial, one that is focused on ex-President Trump, is not likely going to tell the larger story of the people who are complicit if we just focus on the events related to the siege of the Capitol. So the deterrence, I'm not entirely convinced. A second reason we might say is deterrence. Rehabilitation doesn't do it. How about sending a message? We just don't put up with this. Well, I'm not sure who we're sending this message to. If we're sending it to future presidents, I'm skeptical. Because remember, we're talking about behavior that is either legally or practically presumptively beyond the reach of the criminal law, right? If we think that President Trump, while in office, committed crimes, we can indict him for that and we can charge him, we can try him for that and we can convict him of crimes that he committed while in office. So what we're talking about with this impeachment, but if we can't get that, either for practical reasons or legal reasons, some of which Jason addressed earlier, then what we're really talking about is sort of bad behavior that we think the criminal law can't reach. And I'm not sure this message that future presidents be on your guard, that if you do things like this, you will be subject to not only impeachment while in office, but a trial afterwards. And I'm not sure how much effect that's going to have on the behavior of future presidents. To the extent there is, I'm really worried that the message is going to be, if you have enough senators who are loyal to you, the message is, don't worry about it. We got your back. We'll take care of you. All right. So if it's not really retribution, if it's not really going to have the kind of deterrent effect, what about incapacitation, right? Let's ban him from future office. And this is a nice hook, maybe, for why a trial is viable. Since we can't remove him from office, we can at least bar him from holding future office. But I'm not really sure whether this is a standalone reason that makes the trial a good idea. I fear that the takeaway, if that's the reason we're doing this second trial, is that what we're really worried about is that the, whatever it was, 74 million people who voted for ex-President Trump in the last election, our real concern is that they're going to do it again. They're going to exercise their prerogative and vote for Trump again, and we can't have that. This idea that we shouldn't give people a chance, again, if he is convicted and barred from future office, God bless. That wouldn't bother. The Constitution provides for it, but as a standalone reason for going forward, it makes me nervous because I don't know what the future holds. And I worry that this idea of let's keep a at least marginally popular former president from running again, I'm not sure that's enough of a justification, at least in my view. And the final point, and the one that at least I think is the most important, is rehabilitation. Not rehabilitating former President Trump, but rehabilitating us. This idea that it's important to tell the story. And I believe in this a lot. We, if we're going to learn from the past, the first thing we need is a process that uncovers the facts, does so in a non-result oriented way. We want him removed, we don't want him removed. But the integrity of the historical record is important, critically important. That's why historians are so important. I'm not as sure that a Senate trial is the right device for this. It's an adversary proceeding. First of all, it doesn't sound like the two sides are going to be arguing about the same thing. As Jason just pointed out, the Democrats will say he did it, and the Republicans will say you can't be doing this. This trial is illegitimate. And I'm not sure the adversary process is going to produce a sort of well-formed historical record um, that I think is the most important thing to come out of this, because I do think lots and lots of bad things happen, and I think it's really important that we know what those things are. Um, so the good news on this is that Congress is not exactly powerless when it comes to making sure that a relatively unbiased story about January 6th, the time between the election and the inauguration, the last 4 years, whatever we want, we don't have to wait for individual historians to do that. There are mechanisms that we have used before to make sure that a believable story, credible story is told. Think about the Warren Commission report, right, on the assassination of President Kennedy. It was, by the way, created by executive order. This doesn't require an act of Congress. But the Warren Commission, which only had a handful of members on it, as I recall, it was the Chief Justice, Earl Warren, and then the director of the CIA, some civilian, and 2 members of the House, 2 members of the Senate, 1 from each party. And they generated a 888-page report about what had happened. Did it lead to things? No. And of course it's been criticized, but there are ways that we can tell what happened in a way that will help us learn from the last 4 years, the last month, however we want to phrase it. There are also other mechanisms that Congress could, if it were of a mind to, make use of in order to make sure that the story is told. There are these seldom used but available special grand jury reports that can be, with a little bit of statutory tweaking, the current special grand jury report would not fit the situation. But with only a little bit of amendment, special grand juries are designed to look into, and this is a quote, non-criminal misconduct, malfeasance, or misfeasance in office, right? There are ways that we have in hand to make sure that the real fear that many of us has is that the historical record will be clouded by the partisans on each side, and that if what we really want is not to let this stuff happen again, that this is the best way to do it. So I'm not opposed to a second trial on prudential grounds. I'm still not sure. I'm waiting for Vic and Jason to tell me what I should think about the constitutionality of it. But on prudential grounds, I'm not sold on a second trial. Not opposed, but not really thinking we're going to accomplish very much. That's what I got. I'll turn it, I guess, over to Vic.
Thank you so much, Jason and Andy, and thanks everybody for being here. I'll kind of just try to play off of what my colleagues have already put on the table. On the question that Jason tees up of whether the impeachment was properly framed, I think he's right that we tend to be misled, duped, if you will, by the phrase high crimes and misdemeanors into thinking that impeachment is remotely connected to the criminal standards that would permit or prevent people from being put in jail. Obstruction of Congress ran into some difficulties the first time around because obstruction is a very hard thing to prove in the criminal law. Abuse of power was nice because it's so vague and broad. And they should have used something else like that here rather than incitement, which has this criminal analog and this First Amendment baggage. And I just saw on CNN, as Jason was talking, that the president's lawyers today are arguing two things. One, that the Senate doesn't have jurisdiction, if you will, because you can't try a former president. And second, Trump's speech was protected by the First Amendment. And whether the speech was protected by the First Amendment, and by the way, it clearly was, saying you need to be strong, you can't be weak, talking about taking back the country, trial by combat. If you go through political rhetoric over the past 100 or 200 years and try to punish every politician who used imagery like that, there'd be nobody left. There's just no way that you can tease out of those words a clear intent to urge people to commit violence in the near future. But impeachment has nothing to do with that. Impeachment has a legal procedural quality to it, but it's ultimately about political fitness to serve if you are currently in office, or to be disqualified if you should no longer be in office. You can be 34 years of age, and the government can't prevent you from exercising your political rights if you're 34, but it can prevent you from being on the ballot to run for president because you're just not eligible. You're not fit to serve as president. The Constitution says so. So you have a right to speak, but you have no right to be in office. The First Amendment doctrine makes clear that the First Amendment has nothing to do with things that are about removal from office, as opposed to your private speech. Now, on the question of whether trying an ex-president is permissible, Andy, I think the answer is yes. And I've got to be honest with you. People who never said anything about this question before it came up in Trump's case have much less credibility than people who've mentioned an answer to this question when it wasn't on the table. I don't like all these instant experts who happen to have an opinion when we know who the parties involved are. But if you look at the most credible people over time who've weighed in on this question, I think the answer is, and here's why. Because as Jason mentioned and Andy adverted to, the Constitution includes impeachment not just to remove someone, but to disqualify someone. And if you could not be tried after you left office, the disqualification provision would be rendered nugatory because you would just resign right before the Senate was about to convict you. When the writing was on the wall, the Senate would, the votes are there, you just resign, poof, and you can no longer be disqualified. It would be, I think, hard to read that provision of the Constitution as irrelevant. Now, Andy doesn't think that's a great provision because we trust democracy and that people should be able to vote for popular presidents. Again, I can be a really popular 34-year-old and I'm not eligible to be president because the Constitution lays down some standards, and one of them is that you should not have you should not have committed high crimes and misdemeanors while you were in office. And if the Senate so finds, if there's a supermajority of the Senate that so finds, I don't have any problem taking that away from the voters. The protection of the voters is the supermajority requirement in the Senate for conviction. That's what prevents this from being just a tool for one party to deprive popular people in the other party from winning office down the road. I do think that what can be done, it's perfectly permissible to impeach a president who's on the way out and try him afterward. That's not the same question, as Andy points out, as what should be done. But here, Andy, I'll point something else out, and that is at the time the House impeached, unlike last time, first time around, the result was not clear. Mitch McConnell was sending signals that he may vote against Trump. And if Mitch McConnell, along with the 5 who probably Republican senators who will vote against Trump, if he had said he thinks Trump should be disqualified, you could have easily imagined a route to 67. And that would be not only a permissible, but I think a serious reason to have a trial and a conviction. What happened is, in between the time that the impeachment geared up, when the Republicans were saying the right things, and today, you've had this retrenchment, this circling of the wagons, this cowardice, if you will. And now you only have 5 judges or senators who are acting as judges who seem open to considering the factual merits of the case. But that wasn't true earlier. And we're in a little bit of a bind because of the switch in time, if you will, by the Republican leadership, combined with the fact that the Senate has itself a rule that doesn't allow it to just leave an impeachment alone. It has a rule that says once we get an impeachment, we have to hold some kind of a trial. it should probably change that. It should probably free itself up from the obligation to do anything. The Constitution says the Senate has the sole power to try cases of impeachment, not the sole duty to do anything, just as the House never has an obligation to accuse or impeach anybody. It has the power to do so, not a duty to do so. And those are political, pragmatic judgments that have to be made. But the Senate has tied its own hands by these rules. Now, on the question of what to do with, because I like Andy's point about some kind of a story being told, some kind of an inquiry being undertaken. I think that's exactly right. The fact that 45 Republican senators are already on board saying they don't want to engage that, and they're gonna vote on jurisdiction to not get to the merits, if you will. I think that raises an interesting point. All the first years in the audience, including some of mine I see there, are reading Marbury versus Madison. I think Jason probably teaches it early on in his class as well. What's one of the big things that jumps out about Marbury Madison? Well, the court had no jurisdiction, and yet it weighed in on the merits the whole way until it got to that point. Even today, you'll have a lot of justices who say, well, I'm not sure there's jurisdiction, but I'm going to skip past that to address the merits. Indeed, increasingly, you see the justices say, I don't think there's jurisdiction, but if a majority of justices disagrees and is going to reach the merits, then I can and should as well. And notice that 45 is more than a third, so that they can block a conviction, but it's less than half. A majority of the Senate will conclude that there is jurisdiction. And I think that there is, both because the text about disqualification wouldn't have a lot of meaning otherwise, and also because under the state constitutional analogs that led to the federal Constitution, you could impeach and try someone after they left office. The originalist case weighs strongly in favor of allowing the Senate to do this. There's a good op-ed that I sent to Jason in the Wall Street Journal written by Keith Whittington, one of the premier originalist historians at Princeton. And he lays out a very strong case, and I haven't seen anybody rebut any of the evidence that he adduces. And so I do think that there is a good case to be made that they can do it if they want to. Final thing I'll say is, the idea of a commission or something like it, I think is nice. And I was thinking the exact same thing, Andy, that once it was clear that we weren't going to have a real trial, that the Republicans were going to circle the wagon and the result was foreordained, I thought, let's have a bipartisan commission. Biden should appoint a bipartisan commission to do this and make some factual findings. But it now occurs to me that the, 40 or 50 million people who didn't believe the dozens of courts and the attorney general and the head of security in the election security in the federal government and the Georgia Secretary of State and the Georgia governor and the Arizona Secretary of State, the people who don't believe those folks, they're not going to believe a commission either. And they're not going to believe a commission even if you stick Josh Hawley and Ted Cruz on it, and they have to vote in favor of factual findings saying there was no actual fraud or vote stealing. Notice that they never, at the end of the day, in January 6th, they never said that the election was stolen. They just said, the way the president says, I'm hearing that people are concerned about this, in this incredibly circular, I killed my parents, but have mercy on me because I'm an orphan kind of an argument. They never even said that they thought that there was any fire where the smoke was. So, but even if you got them and forced them to actually look at the facts and weigh in, it wouldn't matter to the people. That we're at such a terrible place that I don't know that Warren commissions will have any effect anymore. And I don't know what the answer to that bigger problem is. It's a pretty dark note on which to end my remarks, but that's literally where we are.
Okay, great. So, Andy, I don't want to beat up on you, but I wonder, could I ask you something sort of related to your thinking through alternatives, and of course your expertise in criminal law and criminal prosecutions. Is there any aspect of Trump's conduct, election-related conduct, that would constitute a grounds for prosecution under the criminal law now that he's left office? And if so, Is that a sort of viable alternative to the commission?
To the commission. I'm not sure what you mean by that.
Well, instead of holding a commission for fact finding,
Oh,
we would run it through a regular criminal trial.
I, I think there are plausible grounds for some criminal charges. I think the phone call to the Georgia guy, obstruction, right? I mean, there are people who have been convicted with less than that recording, putting aside the legality or illegality of the recording. But so do I think that criminal charges could be brought? Yes. Do I think they will be brought? Almost certainly no. And even if they, for a lot of reasons, right? I mean, but the problem with criminal trials is that they focus on that, right? What did the president mean when he said this? That becomes the fighting ground on which there's enormous churning, when I think that the important thing is the story of how we got there. And so yes, I do think criminal charges could be brought. I think there's a plausible rebellion or insurrection charge under it's 2383, 18 USC 2383, which, by the way, would have the effect of barring him from future office if he were convicted. But do I think a U.S. attorney somewhere is gonna, no.
And just let me jump in on Andy's point. I think Andy is 100% right, and I would go even farther actually, because I listened to the whole recording, Andy, from that phone call, and I read the transcript. And in context, I'm not sure that I, as a juror, would impute malintent from the word find. That finding the votes could easily have meant in Trump's mind, look, I won by more than that votes. Credit me the votes that I deserve, at least to the extent that puts me over the top. If you seize on the word find, it looks really bad, but in context, I'm not sure that. And part of the problem here is I actually think Trump believes that he was robbed. If this is not a sense where he's contriving to tell a story that he thinks that. One of my favorite characters in all of fiction, George Costanza from Seinfeld, is he told Jerry, look, it's not a lie if you believe it, no matter how ridiculous it is. And I think he does believe this stuff. And so I don't know that a criminal indictment, much less a conviction, is in the offing. And Jason, let's say that a U.S. attorney did bring charges, okay? And a courageous U.S. attorney like Andy did it. If you don't get a conviction, isn't that even worse than not even starting it? Because then it just affirms for the people. And indeed, to the extent that Trump will be acquitted on this second impeachment trial, that goes back to Andy's point. Was it worth the candle? Should it have been brought in the first place if that's going to be how history records it? All of this also shows another big point, and I'll leave it at that. A lot of what President Trump did during his 4 years was not necessarily violating constitutional and other legal rules. It was wrecking norms that are essential to our governing. And that norms are different than legal rules. Legal rules are about courts and juries and judges to enforce. Norms are about the politicians to enforce themselves. And norms are what we have impeachment for. And if you can't have enough bipartisanship to rally around the preservation of norms, the way we did in Watergate and Richard Nixon, that's why he resigned, as Jason pointed out, then we got bigger problems than the stuff we're talking about right now. And we do have those bigger problems. But I think Andy's clearly right about this.
So I'm happy to open things up to questions. We have a good sized audience, and I suspect there are things that you might be wondering about. So if you'd like to either type it in the chat box or raise your hand, I'm sure we can try to do our best to answer whatever questions are on your mind. So anyone want to weigh in with a question?
Or comment. You should feel free to point out that we're all wrong.
While we wait for people to formulate the questions, Jason, I'll take up something that Andy put on the table earlier about who can and should preside over the trial if we're going to have a second trial. Um, uh, Jason and I have a piece that's coming out toward the end of the week in which we argue that um, the Chief Justice perhaps isn't required to preside, because you can read the Constitution's provision saying the Chief Justice presides when the president is on trial to be limited to cases in which the president is a sitting president. Although there are textual arguments that cut the other way as well. We also take the position that there's no formal conflict of interest that would prevent Kamala Harris, Vice President Harris, from presiding. It's true that she is of the opposing party of the president and has been very critical of him, but that's true for any Democrat and some Republicans for that matter. That can't be a basis for recusal. Nor can it be a basis for recusal that she was a beneficiary of the very election that Trump is complaining about, because that's true of so many of the senators. A third of them got elected or reelected this time. In an election that the president believes is rigged. So there are certainly political perceptions and appearances of imperfection that plague most every senator. It can't also be that Harris is disqualified because Trump might want to run again in 2024 if he's not disqualified, and Harris could be an opponent. Josh Hawley could be an opponent. Ted Cruz could be an opponent. Pat Leahy could be an opponent for all we know. So none of those is a reason why any particular senator is technically recused. But because impeachment is a political device, you should be sensitive to these perceptions, even if there's no legal requirement of recusal. And at the end of the day, maybe the Chief Justice is the right person to preside, even if he's not required to do so by the provision in the Constitution. As Jason and I point out, it says when the president is on trial, the Chief Justice shall preside. That doesn't mean that the Chief Justice may not preside, even if someone other than the president is on trial, in this case, a former president. So it would have been nice to know what Chief Justice Roberts thought about his duty and or his power, if invited, to preside over the trial. So that's where we left it, and I'll turn it back to Jason because you got a lot of questions there now.
Yeah, so great. So we have a bunch of questions coming in, and so I guess taking them in order. Question: how does all of this compare to a precedent with respect to prior impeachments after people left office? So as Vic mentioned, if you look at practices in the states. And you look, going back even earlier at English practices, there were certainly impeachments and trials of individuals after leaving office. The problem, which is of significance, some significance, and a particular significance to originalist accounts. With respect to practices in this country, we don't have a lot of data. We don't have many impeachments at all. I mean, I think it's less than 24 total across sort of all members of the federal government, and more than 200 years of history. So we don't have a lot of data. We certainly don't have any data point with respect to a president that would correspond to the current trial of President Trump. We do have one, maybe there's another, but there is one that is getting a lot of mention these days. 1876, the House impeaches William Belknap. He's the Secretary of War under Ulysses Grant. He's involved in sort of corrupt activities with respect to government contracts. He resigns just 2 hours before the House votes. This going back to Vic's point about it's coming, the writing's on the wall, so you resign and purport to therefore escape any sort of punishment. But the House impeaches, and the trial goes to the Senate. And the Senate does spend some time thinking about, do we have power now to try someone after a member of the administration after leaving office? Decides that it does by, I think, a majority vote, but then acquits him. So that's one point of reference, but it's a little more complicated than the way I described it, in that you have reports from at least some of those A is an acquittal, and some of those senators, B, announced that they were voting to acquit because they took the view that he is already out of office. So again, not a sort of clear-cut example from the American context. Vic, anything on that, or should we just feel the?
No, but I will say again, you're not going to have Supreme Court precedent because this is largely a political question up until now. But if you look at the sources of constitutional interpretation, the text doesn't give a clear answer, but the inclusion of the disqualification power, leans in the direction of allowing the Senate to do this. The Senate has, in fact, done it in the one case that it's on the books. Now, it's not a president, but it's a cabinet official. Again, it's hard to argue that, well, it's clear that the Senate doesn't have the power to do this. I mean, it's just, if people were saying that when Obama was president, if the Republicans were saying that, they'd have a little more credibility. But it's pretty clear that they just don't want to engage the merits, and this is a convenient thing to latch onto.
Yeah, and then also maybe just a quick footnote. The text actually might be the Constitution, which we always care about, might be relevant here. So Article 1, Section 3, which talks about the power of the Senate to try all impeachment. There, it doesn't refer to officers of the United States. It refers to no person shall be convicted without the concurrence of 2/3 of members present. A judgment in cases of impeachment should not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit on the United States. But the party convicted shall not nevertheless be liable and subject to indictment, trial, judgment, punishment in the criminal process. So maybe that switch is of some relevance, that a person can be tried, right? And that might be relevant.
Yeah, and I mean, the reference to the party at the end might just be kind of smooth, kind of writing. But at the beginning, saying no person instead of no officer, when Article 2 says the president, vice president, and all civil officers of the United States are subject to impeachment and removal upon conviction, that does lean that way, combined with the state constitutional analogs.
Okay, so we'll give you then, Vic, the next question. What is the status of prohibiting from holding office if there's no conviction? So can you bar someone, I guess, from holding office without a conviction?
No. So it says judgment. The Constitution says if you're convicted, you're removed from office automatically if you're still in office. And then it says judgment in cases of impeachment can extend no farther than removal and disqualification. But if the judgment is one of acquittal, it's hard to see how you can impose any sanction.
Okay, I think that.
And notice also that history, in a criminal case, if you don't have unanimity either way, we call it a hung jury. We don't say there's a conviction or an acquittal. In the impeachment context, if somebody is tried for an impeachment and there aren't 2/3 to convict, we say he's been acquitted. Bill Clinton was acquitted. And I think that's also relevant. If you acquit someone, it's hard to attach any negative consequences to that.
And indeed, the message after all of this on Trump's part is, I was, twice impeached, twice tried, twice acquitted, right? And that's going to be the message he's going to trumpet. Okay, next one is, if there was still January 7th, so the president's still in office, could the 25th Amendment apply, relevance of that? My quick answer is, I don't think the 25th Amendment had any bearing really on Trump's conduct. I see it as a provision that deals with disability rather than culpability. And I thought the 25th Amendment argument just didn't really make much sense. But Vic, maybe you have a different view.
No, I agree with that. One question says it's off topic, but it's not really off topic. It says, any thoughts about the Dominion lawsuit against Rudy Giuliani? Here's how I would say that's very relevant to this. I don't know enough I didn't read the complaint. I don't know enough. But when people make factual assertions like this software switched votes, that can be the basis of libel and other civil actions in a way that statements like the election is rigged or I was robbed can't be. Goes back to Jason's point about the First Amendment, protection of speech. Brandenburg protects incitement. New York Times versus Sullivan protects kind of rhetoric and exaggeration generally. But when we're talking about the legal sanctions, we are operating in a narrower world. Whether it's the criminal law, where Andy pointed out you need to prove intent, which is hard, or libel, where you gotta hang your hat on factual misrepresentations, factual untruths. So there's lots of possibilities there. But when we're talking about the kinds of things that we really thought Trump did wrong, some of them were factual untruths, but he wasn't slandering anybody in particular the way Giuliani apparently was. He was just making grandiose falsehood statements about the validity of the election, and the remedy for that is political more than it is legal.
And the next question actually follows right on from that, and we can direct it back to Andy because it goes to many of his observations. The question about, how do you tell the story in a way that would overcome, I guess, or wean people from the belief in narratives that lack evidentiary support? How do you persuade, given sort of all of the concerns you raised, Andy, and so having run through the different options, and Vic's comment that the commission issues the report and that is just fake news as usual. Andy, give us the solution.
Okay. You don't, right? That you can't. First of all, you can't persuade everyone. There may be an especially large group that is not persuadable. You tell the truth. You tell the facts. You get as down the middle as you can on this stuff. And even if for many people you will not persuade, but you will change the discussion, right? You will set a baseline against which people have to argue. So the Warren Commission, to use the example, didn't, persuade some people that this wasn't, a Russian plot or a CIA plot or a Marilyn Monroe plot or whatever it was. But instead, it provided a vast amount of information against which people now have to, serious people, now have to respond. This sounds a little defensive and a little self-serving, but even with President Clinton, right, there, as you'll recall, there was a very long narrative about the events leading up. People attacked the decision to impeach President Clinton, Ken Starr's behavior, et cetera, on all sorts of grounds. But one of the grounds that was relatively quiet was these facts are wrong. There was very little of that, and it, at least in my view, it changed the narrative. It still didn't persuade people that he had committed an impeachable offense. He should be removed. He shouldn't be removed. But laying out the facts as best you can, I think, is the best we can do.
I think Andy's exactly right about that, and I do think that the Clinton example is good because the facts about what Bill Clinton did aren't really in dispute. Now, I don't remember them being in that much dispute even going into the Starr report, but
yeah.
Well,
Lewinsky. No, no, they were in huge dispute.
Okay, so in any event, what Bill Clinton did with Monica Lewinsky and others, that much is clear. Again, I don't know if it changes the bottom line attitudes of that many people, but the other thing Andy said, I think, is important too. Look, we may be in a world where we can't convince a very large number of people, but if you can cut that large number of people down into a still large number of people, but a smaller number of people, that may be all we can do. If you can get from 50 million skeptics to 30 million skeptics, that's still 10% of the population and 20% of the voters, but it's better than it is now.
And here also maybe a plug for law schools and legal training. Vic and I wrote something some time ago in this context, essentially saying, the heroes, or one set of heroes in all of this, in terms of the challenges that were being asserted against the election processes and outcomes, were the lawyers and the judges with legal training. Because one of the things we do in law school is we talk about law. We talk about the importance of fact and testing facts and insisting upon reliable evidence. So I think that those of you who are in law school, or maybe thinking about attending law school, this is an important and perhaps increasingly important skill to be able to sift facts and test facts, and say when facts aren't real, and here's the counter evidence. And we saw that in the events after the election.
And Jason, let me just add a footnote to that. You'll often hear supporters of the president say that those lawsuits shouldn't be credited too much because they never really looked at the claims on the merits. They never really looked to see whether there was voting fraud. To be sure, some of them where the claim was based on a legal theory that was not viable either as a matter of law, or it was brought too late because it should have been brought earlier. If you're challenging something the Pennsylvania Supreme Court did to allow people to vote, you don't challenge it after the people have voted. You do it months earlier when they could have voted another way if the Pennsylvania Supreme Court, so latches was a powerful thing. But it would be a helpful exercise if someone went through the 50 to 60 odd cases and highlighted the dozens of cases where the judges did invite the plaintiffs to introduce evidence and the plaintiffs failed miserably. So it's not as if all of these were dismissed on latches or motions to dismiss for failure to state a claim. A lot of them were evidence-based, and it would be nice if somebody kind of packaged that in a way to respond to this claim.
Okay, next question. What is the remedy for a coup? I think the answer to that is leave the country, isn't it? This wasn't a coup, right? Maybe it's an attempted coup, but one of the actually remarkable things about the January 6th incidents is I was interviewed on radio right after that, and I was asked, what was your impression of that? And I said, well, sort of, horrified that it happened, but actually really impressed that the House and the Senate members picked up again with their work and continued on and actually got this thing done. And so there's a kind of resilience to the democratic system that evidenced.
Sounds like Mitch McConnell.
Yeah, exactly. Would a motion, this is a good one. Would a motion to censor Trump in the Senate provide any deterrent effect? There was some talk about this as a sort of alternative to impeachment. I'm actually, maybe Andy and Vic, you have some sense of whether that might have gotten support by Republicans in the Senate, right? Don't go ahead with impeachment, but we'll approve a censor motion. Thoughts about whether that was a possibility ever and the benefits of that?
Like most things, it's a strategic question. If you think you have a chance at impeachment, and this goes back to Vic's point that maybe at the time of the impeachment itself, it really wasn't clear whether there'd be an acquittal because emotions were certainly running hot after January 6th. And so you might, if you're a Democrat, you might not favor censure if you thought that will kick the legs out from under any potential impeachment. And for a lot of people, I think they would think on the scale of things that presidents do, this is pretty high up there in terms of impeachable conduct. So I'm not sure that the Democrats would have gone for it. The Republicans might have for, obviously the opposite reasons.
But, Andy, I think Andy's right about that the Democrats thought they had a shot here, so they took it. But now that they don't have a shot, I continue to think a censure motion is a way to require the 45 senators who say we don't have the power, because no one denies they have the power to censure.
Right.
And so get them on record so that they can either deny or embrace the story that's being told during the impeachment trial, the one that Andy describes. You might not get 80, but maybe you'll get something more than 55, and that would be helpful.
And there's no bar to censoring a former president, right?
Well, I mean, the only potential bar is bill of attainder. But I don't think that would be a constraint. Now, maybe the same 45 would say, oh, this is a bill of attainder, we can't do that. And maybe, they've never heard of bill of attainder before now, but they would learn of it later, I'm sure, because they've had strong views about it for decades.
Although it would be more likely to be a bill of attainder if they tried the overreach and said, we will censor you and prohibit you from holding office in the future, right? I mean, if you tried to attach some tangible sanction to it, I think you'd have more. But
this came up during Clinton's impeachment. That the question is, well, could they have censored him instead? And would that have been a bill of attainder? And I wrote at the time I didn't think it would be a bill of attainder, and I still don't think it would.
So maybe we'll take one last question and then we'll end. It's from Carrie Sanderson. An interesting question about the social media ban or bans with respect to Trump. The Twitter account shut down and other outlets shut down. Does that, Carrie asks, does that make it easier for Republican senators to circle the wagons, reduce pressure on them to hold him accountable, or there are other sort of implications from that? Any thoughts about the relevance of that?
Well, I'm not a social scientist, political scientist, or communications expert, but it seems to me if he's not saying crazy things all the time, it's easier to make the principled argument that he's already out of office and we shouldn't do anything. It's just in political terms, it's just harder to say anything that can be construed as defending the guy if he continues to offend.
Yeah, I worry a little bit about the whole let's balkanize Twitter, right? And so we've got right-thinking people who say good things, and then we've got I sort of feel like, which is what I am, the parent of teenagers. Part of me wants to hear what they're talking about. I'd rather have them sort of be upstairs having the conversation than down in the basement where I can't hear them anymore. So I'm not sure that cutting them, saying, I mean, Twitter can do whatever it wants, right? I mean, that's their private entity. They have no First Amendment obligations here, but I don't know. I'd rather keep an eye on what's being said.
Yeah, on the question of whether it's a good thing for Twitter to have banned him, that's a much more complicated question. And
I took that to be the question. I'm sorry, if I misunderstood.
Yeah, no, I share Andy's concern about that. I mean, Andy's right. Look, these are not state actors. There's no First Amendment issue there, but there could easily be some kind of an antitrust issue if there's so few of these platforms that reach so many people. So I do think that raises a whole host of questions that we're just starting to unravel.
Yeah, and the just final point. So the relative quietness from the Trump Twitter account, and it's been very quiet, and you sort of notice that these days. I think that context might, as I suggest Carrie's question maybe is pointing at, might alter a bit the context in which we think about Trump representing a continuing threat and sort of engaged in craziness and so on. So
right, that was my reaction to the question.
And it may actually serve his interest in some way that going to it's over, let's put this behind us, and he's not causing any trouble at this point. If he were continuing to tweet sort of crazy stuff about the election, then harder to say that he's that there's nothing more to be concerned about. So it may be an interesting dynamic.
Yeah, I mean, legally speaking, it wouldn't really go to the question of whether the Senate has the power to try somebody. But as we know, this is not really kind of about legal niceties. It's about what you can sell to the folks back home.
Great. And so with that, Andy, Vic, thank you so much for doing this, and thank you to all of our audience members. We may well be back, so stay tuned, and we'll see what happens. Thank you.
Thanks, everybody. Thanks. Thanks, Andy. Thanks, Jason.
Thanks, Beck. Okay. Thank you, Jason.